right, hi, welcome back. Attorney Steve Vondran. Today, big decision in breaking legal news with Attorney Steve. All right, Supreme Court has come down on this, what we call the Colorado ballot case. It's a case a lot of people were watching. I had a client of mine call him a fan, said, I'd like to hear you actually do the reading on this. So while I normally don't get into the politics of things, I thought this was a good case. Maybe we can learn something here today. All right, this decision just came down. As you may recall, the Colorado Supreme Court said that Trump could not be on the ballot because he engaged in insurrection. The lower court so found that he engaged in resurrection. It flipped through the Colorado courts, eventually went up to their Supreme Court, and the Supreme Court said Trump is disqualified from appearing on the ballot under the section we're going to talk about in a second. So, case was ultimately appealed to the United States Supreme Court. A writ of certiorari, I think it's in here somewhere. Writ of certiorari. I have a video on that I will post down if you're wondering a little bit more about what is that, how does it work. But they took it up on appeal on a constitutional issue, and those are the power of judicial review. The Supreme Court has a power to take a look at that since it's based on a constitutional question. All right, so this just came down. Per curiam decision. Per curiam, anybody know what that means? It means unanimous decision. Now, in the Supreme Court, it's always very interesting. People say, well, everybody takes an oath to swear to uphold the Constitution, which is true. Lawyers, officers, officials, city council, all kinds of people, police officers, and so forth and so on. And a lot of people take that oath. And so many decisions from the United States Supreme Court come back 5-4. So knowing what the Constitution actually is always another question. And so let's get started here. All right. A group of Colorado voters, and I'm only going to read the first, 9 pages. There are some concurring opinions, and I won't go into those. So it's per curiam, 9-0 by the Supreme Court said this is not permissible. A group of Colorado voters contends that Section 3 of the 14th Amendment to the Constitution prohibits former President Donald J. Trump, who seeks the presidential nomination of the Republican Party in this year's election, from becoming president again. The Colorado Supreme Court agreed with that contention. It ordered the Colorado Secretary of State to exclude the former president from the Republican primary ballot in the state and to disregard any write-in votes that Colorado voters might cast for him. Former President Trump challenges that decision on several grounds because the Constitution makes Congress, rather than the states, responsible for enforcing Section 3, which we're going to talk about in a second, against federal office holders and candidates. We reverse. Okay, so Supreme Court saying, Colorado Supreme Court, we do not like the way your interpretation, I should say. And let's move on. Last September, about 6 months before the March 5th, 2024 Colorado primary election, 4 Republican and 2 unaffiliated Colorado voters filed a petition against former President Trump and Colorado Secretary of State Jena Griswold in Colorado State Court. These voters, whom we refer to as the respondents, contend that after former President Trump's defeat in the 2020 presidential election, he disrupted the peaceful transfer of power by intentionally organizing and inciting the crowd that breached the Capitol as Congress met to certify the election results on January 6, 2021. This is the alleged insurrection. One consequence of those actions, the respondents maintain, is that former President Trump is constitutionally ineligible to serve as president again. So there we have our constitutional question right here. Their theory turns on Section 3 of the 14th Amendment. Section 3 provides, let's take a close look at this, no person shall be a senator or a representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. but Congress made a vote of 2/3 of each house remove such disability. So that's what's at issue. And so there's a lot of different words that need to be historically examined and reviewed to figure out just exactly what this means. According to the respondents, Section 3 applies to the former president because after taking presidential oath in 2017, he intentionally incited the breaching of the Capitol on January 6th in order to retain power. They claim that he is therefore not a qualified candidate and that as a result, the Colorado Secretary of State may not place him on the primary ballot. After a 5-day trial, the state district court found that former President Trump had engaged in insurrection within the meaning of Section 3. Now, I don't know, when that says trial, I don't know if that was something, I don't follow politics all that closely. I don't know if that was something that Trump actually showed up and gave testimony and confronted witnesses and provided, I don't know if that actually happened, but after a 5-day trial, the district court found that he engaged in insurrection within the meaning of Section 3. But nonetheless denied the respondent's petition. So the court held that Section 3 did not apply because the presidency, which Section 3 does not mention by name, is not an office under the United States. So the district court found that there was an insurrection, but they said because the presidency is not an office of the United States that it didn't apply. So you couldn't prohibit him from being on the ballot. And that the president is not an officer of the United States within the meaning of that provision. In December, the Colorado Supreme Court reversed in part and affirmed in part by a 4-3 vote. Reversing the district court's operative holding, the majority concluded that for purposes of Section 3, the presidency is an office under the United States, and the president is an officer of the United States. So you see here we have even courts within a single state disagreeing as to things. So these can be tricky questions of law, these constitutional law questions. The court otherwise affirmed holding 1. Colorado election code permitted the respondent's challenge based on Section 3. 2, that Congress need not pass implementing legislation for disqualifications under Section 3. So they said we don't need Congress to do anything, we can do it by ourselves. 3, that the political question doctrine did not preclude judicial review of former President Trump's eligibility. 4, that the district court did not abuse its discretion in admitting into evidence portions of a congressional report on the events of January 6. 5, that the district court did not err in concluding that those events constituted an insurrection and that former President Trump engaged in that insurrection. And 6, that former President Trump's speech to the crowd that breached the Capitol on January 6 was not protected by the First Amendment. So they said you're inciting a riot, you're going too far. First Amendment is not absolute, it has limits. So, okay. The Colorado Supreme Court accordingly ordered Secretary Griswold not to list President Trump's name on the 2024 presidential primary ballot or count any write-in votes cast for him. Chief Justice Boatwright and Justices Samore and Birkencotter each filed dissenting opinions. Under the terms of the opinion of the Colorado Supreme Court, its ruling was automatically stayed pending this court's review. We granted former President Trump's petition for certiorari, which raised a single question. It's nice when you only have one question. Did the Colorado Supreme Court err in ordering President Trump excluded from the 2024 presidential primary ballot? There's your question. I think you already know the answer. And they said we reverse. They reversed the Colorado decision. All right, let's see why. Again, per curiam, what is that? That means all judges and justices were in concurrence, okay? Proposed by Congress in 1866 and ratified by the states in 1868, the 14th Amendment expanded federal power at the expense of state autonomy and thus fundamentally altered the balance of state and federal power struck by the Constitution. Section 1 of the amendment, for instance, bars the states from depriving any person of life, liberty, or property without due process of law. That's what we call the Due Process Clause. Life, liberty, or property without some sort of due process, then the question becomes what process is due, okay? Denying to any person the equal protection of the laws, it's what we call the Equal Protection Clause. And Section 5 confers on Congress the power to enforce those prohibitions, along with other provisions of the amendment by appropriate legislation. Section 3 of the amendment likewise restricts states' autonomy, but through different means. So it gets a little complicated here. Just bear with it. I'm just going to read through it. It was designed to help ensure an enduring union by preventing former Confederates from returning to power in the aftermath of the Civil War. Statement of Representative Stevens warning that without appropriate constitutional reforms, yelling secessionists and hissing copperheads would take seats in the House. Statement of Senator Howard lamenting prospects of a state legislature made up entirely of disloyal elements absent a disqualification provision. Section 3 aimed to prevent such a resurgence by barring from office those who, once having taken an oath to support the Constitution of the United States, afterward went into rebellion against the government of the United States. Section 3 works by imposing certain individuals a preventative and severe penalty, disqualification from holding a wide array of offices, rather than by granting rights to all. It is therefore necessary, as Chief Justice Chase concluded, and the Colorado Supreme Court itself recognized, to ascertain what particular individuals are embraced by the provision. Chase went on to explain that to accomplish this ascertainment and ensure effective results, proceedings, evidence, decision, and enforcements of decisions, more or less formal, are indispensable. For its part, the Colorado Supreme Court also concluded that there must be some kind of determination that Section 3 applies to a particular person before the qualification holds meaning. The Constitution empowers Congress to prescribe how those determinations should be made. The relevant provision in Section 5 is Section 5, which enables Congress, subject of course to judicial review, to pass appropriate legislation to enforce the 14th Amendment, or, as Senator Howard put it at the time the amendment was framed, Section 5 casts upon Congress the responsibility of seeing to it for the future that all the sections of the amendment are carried out in good faith. Congress's Section 5 power is critical when it comes to Section 3. Indeed, during a debate on enforcement legislations less than a year after ratification, Senator Trumbull noted that notwithstanding Section 3, hundreds of men were holding office in violation of its terms. The Constitution, Trumbull noted, provided no means for enforcing the disqualification, necessitating a bill to give effect to the fundamental law embraced in the Constitution. The enforcement mechanism Trumbull championed was later enacted as part of the Enforcement Act of 1870. If you love history, constitutional law is your thing because it's history galore, okay? They try to find out what these words mean. What were they trying to do when they drafted the Constitution in its terms? All right, let's move down to this. This case raises the question whether the states, in addition to Congress, may also enforce Section 3. Are they both allowed to enforce it? Can only one enforce it? We conclude that states may disqualify persons holding or attempting to hold state office, but states have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency. So I guess you could call this the essential case holding right here. So with regard to Section 3, states can do what they want to disqualify state people, but they don't have power in regards to federal offices, especially the presidency. In our federal system, the national government possesses only limited powers. The states and the people retain the remainder. Among those retained powers is the power of the state to order the processes of its own governance. In particular, the states enjoy sovereign power to describe the qualifications of their own officers and the manner of their election, free from external interference, except so far as plainly provided by the Constitution of the United States. The Taylor versus Beckham case from 1900. You love when you're quoting cases from the 1900s. Although the 14th Amendment restricts state power, nothing in it plainly withdraws from the states this traditional authority. So they have that authority, and after ratification of the 14th Amendment, states used this authority to disqualify state officers in accordance with state statutes. So there is, certainly you have the Worthy versus Barrett case, state versus ex rel Sandlin versus Watkins, where state officers were excluded, county sheriff, state judge. Such power over governance, however, does not extend to federal officers and candidates, because federal officers owe their existence and functions to the united voice of the whole, not of a portion of the people. Powers over their election and qualifications must be specifically delegated to rather than reserved by the states. All right, so that's your main holding right there in the blue, okay? And I'm going to post this up on my website if you want to watch and read this whole thing and read the additional concurring opinions. But nothing in the United States Constitution delegates to the states any power to enforce Section 3 against federal office holders and candidates. Moving to the next section here, the respondents nonetheless maintain that states may enforce Section 3 against candidates for federal office, but the text of the 14th Amendment on its face does not affirmatively delegate such a power to the states. The terms of the amendment speak only to the enforcement by Congress, which enjoys power to enforce the amendment through legislation pursuant to Section 5. This can hardly come as a surprise, given the substantive provisions of the amendment embody significant limitations on state authority. Under the amendment, states cannot abridge the privileges or immunities. This is what we call the Privileges and Immunities Clause of the Constitution. Deprive persons of life, liberty, or property without due process of law, cannot deny equal protection, or deny male inhabitants the right to vote without thereby suffering reduced representation in the House. I'm not sure what that means. On the other hand, the 14th Amendment grants new power to Congress to enforce the provisions of the amendments against the states. It would be incongruous to read this particular amendment as granting the states the power, silently no less, to disqualify a candidate for federal office. The only other plausible constitutional sources of such a delegation are the Elections and Electors Clauses, which authorizes states to conduct and regulate congressional and presidential elections, respectively. But there's little reason to think that these clauses implicitly authorize the states to enforce Section 3 against federal office holders and candidates. So no penumbra for this. Granting the states that authority would invert the 14th Amendment's rebalancing of federal and state power. The text of Section 3 reinforces these conclusions. Its final sentence empowers Congress to remove any Section 3 disability by a 2/3 vote, as we read up above, okay? The text imposes no limits on that power, and Congress may exercise it any time as the respondents concede. In fact, historically, Congress sometimes exercises amnesty power post-election to ensure that some of the people's chosen candidates could take office. But if the states were free to enforce Section 3 by barring candidates from running in the first place, Congress would be forced to exercise its disability removal power before voting begins if it wished for its decision to have any effect on the current election cycle. Perhaps the state may burden congressional authority in such a way when it exercises its exclusive sovereign power over its own state offices. But it is implausible to support that the Constitution affirmatively delegated to the states the authority to impose such a burden on congressional power with respects to candidates for federal office. States have no power to retard, impede, burden, or in any manner control the operation of the constitutional laws enacted by Congress. Nor have the respondents identified any tradition of state enforcement of Section 3 against federal office holders or candidates in the years following ratification. So they do not have any precedent on their side, it looks like. Such a lack of historical precedence is generally a telling indication of a severe constitutional problem with the asserted power. So again, courts don't really like to make law, so to speak. So when you come in a case like this, you need to have some kind of precedent. But then again, if you had precedent, the case might not actually be here. They might have refused to take it up on certiorari. And it's especially telling sign here because as noted, states did disqualify persons from holding state offices following the ratification of the 14th Amendment. That pattern of disqualification with respect to state, but not federal offices provides persuasive evidence of a general understanding that the states lacked enforcement power with respect to the latter. All right, and I think we're just about done here, but you know what? That's about it. We could go on. Let me hit this last piece here. Finally, state enforcement of Section 3 with respect to the presidency would raise heightened concerns. In the context of a presidential election, state-imposed restrictions implicate a uniquely important national interest. But state-by-state resolution of the question whether Section 3 bars a particular candidate for president from serving would be quite unlikely to yield a uniform answer consistent with the principle that the president represents all the voters in the nation. Conflicting state outcomes concerning the same candidate could result not just from differing views on the merits, but from variations in state law governing the proceedings that are necessary to make Section 3 disqualification determinations. Some states might allow a Section 3 challenge to succeed based on a preponderance of the evidence, while others might require a heightened showing. Certain evidence, like the congressional report on which the lower courts relied here, might be inadmissible in some states, but inadmissible in others. Disqualification might be possible only through criminal prosecution as opposed to expedited civil proceedings in particular states. Indeed, some states like Colorado or Maine, where the Secretary of State recently issued an order excluding former President Trump from the primary ballot, procedures for excluding an ineligible candidate from the ballot may not exist at all. The result could be, well, that a single candidate would be declared ineligible in some states, but not others based on the same conduct. So you could have this patchwork where some states are going, he did this or she did that. You're disqualified under our laws. We have different evidentiary laws, or we have this law or that law. And this patchwork that would likely result from state enforcement would sever the direct link that the framers found so critical between the national government and the people of the United States as a whole. But in a presidential election, the impact of the votes cast in each state is affected by the votes cast, or in this case, the votes not allowed to be cast for the various candidates in other states. All right, so for the reasons given, responsibility for enforcing Section 3 against federal office holders and candidates rests with Congress and not the states. The judgment of the Colorado Supreme Court, therefore, cannot stand. All 9 members of the court agree with this result. Our colleagues writing separately further agree with many of the reasons, so forth and so on. So if you want to read some of the concurring opinions down here, concur in part, and so forth, raising other concerns, feel free to read it. But that's it. That's kind of what happened there. And I just wanted to get that out to you. And these aren't always fun and easy to read if you don't have a little bit of a background in the Constitution. But guys and gals, ladies and gentlemen, the Constitution is a very small little book. You can pick up one and you can read it. But again, it's not going to tell you everything. It's not going to resolve every answer that pops up. This is where the Supreme Court of the United States, the court of last resort, comes in. Hope you like this video. General legal information only, not legal advice. Feel free to share it. And make sure to subscribe.